Greetings and on behalf of United Way of the National Capital Area and the entire staff, welcome to Project Community Connect. I'm Scott Meghan, the Director of Research and Evaluation at the United Way of National Capital Area, and thrilled to be here to moderate today's panel. United Way NCA expanded its annual Project Homeless Connect in response to the COVID-19 pandemic over the past year to align with its strategic programmatic direction focused on achieving equity for all of our community members, regardless of race, gender, income, and ability. We're excited to work with our partners and community-based organizations on PCC's mission to build community, shift mindsets through personal experience and connection, and provide critical resources at no cost to individuals and families in Washington, D.C. and the surrounding counties in Maryland and Northern Virginia. The workshop topics for this week of Project Community Connect include healthy eating on a budget, eviction prevention and rental assistance, saving on utilities, chronic disease prevention and management, starting a small business, legal services in the areas of expungement and immigration, among several others. In this time of COVID, there's no segment of society that has not been touched by this public health crisis, particularly those households who are struggling to afford the basic household necessities, including housing, childcare, food, transportation, healthcare, and even a basic smartphone plan. And in this unprecedented time, and as we all continue to navigate uncertainty, it remains imperative that your United Way provide innovative ways to reach workers and their families throughout the DMV. Today's session is going to be focused on housing law basics during the COVID-19 pandemic. It's going to provide an overview of housing law in Virginia, including information on evictions, the conditions and security, and special considerations for COVID-19 protections. We'll also be touching on rental assistance and recent trends in eviction protection. I'm thrilled to introduce the panelists for today's session. I would like to introduce Meghan Zimman, Managing Attorney of for the Fairfax branch of Legal Services of Northern Virginia. Ms. Zimman has worked at Legal Services of Northern Virginia for a decade, representing homeowners in foreclosure, tenants, and consumers in litigation and advocacy efforts. Joining her today is Edgar Gonzalez, a general staff attorney with Legal Services of Northern Virginia, where he represents tenants and consumers in litigation. Prior to joining the Legal Services of Northern Virginia, Edgar gained experience in the practice areas pertaining to immigration and personal injury. I am thrilled to learn more from them today, and I'll pass it over to Edgar.
Thank you, Scott. Hello, everyone. Excited to be here. Thank you for the opportunity to present. There we are. Excellent. So like Scott introduced, my name is Edgar Gonzalez. I'm one of the housing attorneys here in Fairfax County. Next slide, please. So this is going to be a very fast overview. There are 4 parts to our general presentation. What we're going to talk about is not verbatim what's on each slide, because that would take too long. So we're going to give summaries of what's written on the slides. You can always go back and review the slides later. I'm covering parts 1 and 2. So I'll do a general intro about our organization, Legal Services in Northern Virginia, what we do. And then part 2, we're going to discuss the general housing law and issue spotting in these situations. Next slide. Part 3 was where Ms. Zimman will take over to discuss new protection for tenants facing evictions for unpaid rent. And she'll wrap up with part 4, which will be other protections or considerations when dealing with housing situations. So who we are. So we're Legal Services Northern Virginia. We're a nonprofit law firm that helps with helping people that are in marginalized communities or people facing poverty. We really do our best to ensure that we bridge the justice gap here in Virginia. That is our driving mission, and helping people access the courts and access justice who otherwise wouldn't have means. This is just a slide to explain how to contact us and how to reach out to us. For example, because of the COVID pandemic, we used to have a lot of walk-in opportunities. Now, our main ways to contact us is either through calling our main line or applying online. Those are the preferred ways. If it's crucial to talk to us in person where the person doesn't have access any other way, they would need someone to call ahead to make an appointment for an in-person take-in. And that, of course, would involve COVID checks and things of that nature to make sure everyone is safe. This is just a quick summary of the types of laws we practice. As I stated before, we're really focused on battling poverty, assisting people in need, marginalized communities. These are sectors of law that have been identified as places that need a lot of assistance, and this is where we come in. We have limitations. We can't do any type of law, so we don't do criminal, traffic, immigration, or personal injury. As our name states, we serve all of Northern Virginia. Fairfax, because of its size, has 2 office locations. We service Prince William, Alexandria, Arlington, Loudoun. And we also offer limited assistance to Rappahannock and Fredericksburg. That usually looks more like referrals, talking to clients, giving advice. Okay, now we're on to part 2. This section is a lot of information. So for this section, I'm going to summarize the slides and just articulate the important parts of each slide. You'll have the slides, you can read the slides and get into the weeds of it. In the interest of time, I cannot read each and every slide verbatim. We're going to begin at the beginning, the Virginia Residential Landlord Tenant Act, the VRLTA. The VRLTA, as of 2019, is the place to go for residential landlord tenant issues. It is the statutory code of Virginia. There used to be more acts out there that you could kind of use or not use depending on how your lease was drafted. 2019 was a big year of overhauling the statutory code that controls landlord tenant issues in Virginia. So now it's very simplified. According to the VRLTA, if you are living in a single house, multifamily, or whatever residential situation, you are covered by the VRLTA. There is a small list of exceptions within the statute that include things like campgrounds. If someone's not paying rent, they're not really a tenant. Dormitories for like colleges and other situations, things like that. It's a very narrow list of exceptions. As of 2019, because of the big overhaul, now if you enter into an oral lease or somebody comes up and says, I didn't have a written lease, I don't have any rights, that's no longer true. The statute has a default lease that kicks in, and it's what most people think of when they think of a lease. 12-month tenancy, rent due at the first of every month, reasonable late fees can be charged, security deposit with a limit of 2 months max. Landlord tenant can still enter into a written lease. So just because a default lease kicks in does not mean that there is no way for them to suddenly enter into a written agreement. You could always do that. Here are some variations that a lot of people aren't aware of. When we think of a lease, most people think month to month, 1 year, like I stated in the last slide. But in reality, under the Code of Virginia, a lease could even state week to week, 6 months, over a year in lease. It's a contract. Leases are agreements between 2 parties. So whatever they decide to work out and agree to is what the lease can be. When a lease terminates, it's automatic. That doesn't necessarily mean someone has to leave the tenancy, but the controlling terms of that contract and the timeline have ended. Now, depending on what the lease says, you could automatically become a new lease. It could become a month-to-month lease, or for it to continue, someone would have had to give advance notice before termination. Notice in Virginia typically takes on the form of 30 days, 60 days, or 90 days, 1 month, 2 months, 3 months. Like I stated, the renewals can happen month to month or on different conditions. That's where it becomes a question of, well, what does the lease say? Now, after a lease has been formed, oh, can we go back 1 slide? Thank you. After a lease has been entered into, what happens to get out of a lease, or how do you remove a tenant from a situation, otherwise known as an eviction? There are different types of ways to file for an eviction. We're going to begin by discussing non-payment of rent, which tends to be the most common reason why people are removed from housing. So again, 2019, big year in housing law. As of that year, there are now 4 ways that someone can remedy or fix an issue with unpaid rent. The first one is what most people know off the top of their heads. There's a 5-day grace period in Virginia. If you miss the first day of rent, you have up until the 5th day of the month to just pay it, and that's fine. Everything's okay, everything moves forward. As of the 6th day of the month, the landlord can then give you what's called a 14-day notice. And that just means it's a written notice letting you know, hey, you missed the rent payment. It's been over 5 days. Here's the late fee if the lease allows for them. And if you pay the late fee plus the rent, you're fine. A lot of cases don't get past this point. A lot of cases just resolve themselves by paying the overdue amount. After 14 days has passed and the notice period has terminated, as of the 15th day, the landlord can then go to court and file what's called an unlawful detainer. The unlawful detainer is beginning the process of an eviction. Now, we're getting into what's called right of redemption. Right of redemption has 3 parts. There's right of redemption, there's redemption just by the tenant, or there's redemption tender, which is a different situation. And in the next slide, we'll discuss extended right of redemption, which is the last opportunity to not be evicted. So what's a redemption? A redemption is just when the tenant pays all outstanding fees. Their outstanding rent, the late fees, court costs, because now they filed, and to file something in court, the plaintiff or the landlord needs to pay costs for the filing, and perhaps any attorney fees if there's an attorney attached. If the tenant or the resident pays all that, they've redeemed. The file gets closed, everything goes back to normal. They continue back on their month-to-month payment or whatever the cost may be. Redemption tender is slightly different. Redemption tender is when a third party agrees to pay partial or all of the outstanding amount. For this to work, the tenant or the defendant at this point needs to show up what's called the first return, which we'll discuss later in the slideshow, present the proof of a third party who's agreed to make this redemption to pay for them, and then the court will give 10 days for them to actually do the amount. We'll all come back at 10 days. If everything's paid off and there's nothing left over, the tenant has been redeemed and can go back to living the unit as before. Okay, so now we're into what's called the extended right to pay and stay, or the extended right of redemption. Now, this situation comes into play if everything else has passed. When I say everything else, I mean the 14-day notice wasn't paid for the 14-day notice. An unlawful detainer was filed. A first return was attended. A trial was had after the first return. The judge agreed with the plaintiff or the landlord that the amount is due and needs to be paid. The landlord took his thing down to the clerk to turn in to then submit to the sheriff to have a writ of eviction. The sheriff has gone over to the house the first day to knock on the door and say, hey, you have these many hours before we come and evict you, 72 hours or 3 days. Like I said, we'll go into more detail later in the presentation. It's just that at this point, this is where the extended right of redemption comes into play. Up until 48 hours of the date of eviction, up until the last 2 days leading up to the date of eviction, the tenant can still redeem. You can still pay the court costs, pay the fees, pay everything that's outstanding. And if you notify in writing the landlord and the sheriff to make sure the sheriff knows it's all been done and the court has been submitted to the court, you can still stay in that unit. You are not being physically removed. That is the last ditch effort. But think about it, the timelines. The sheriff by law has to give at least 72 hours of notice that they're gonna come to take away your housing. And then within that 72 hours, you have to tell them ahead of at least 48 hours notice that you've been able to pay off everything. So that's a 24-hour window right there, that once you've missed that mark, it becomes really difficult to prove or to be able to redeem. Things happen, the sheriff might be late, they might not be able to do it within 72 hours, but those are important timelines. This is the last ditch effort to not be physically removed from housing. So we had just finished what's called non-payment of rent evictions. Now we're on a different type of eviction, and this is for conduct. Conduct is when somebody does something that breaches the terms of the lease. And when we say breaches, there's a legal term of art called material breach, which means it's important. It's something that severs the core promises of the lease. And when this happens, the landlord needs to give the tenant what's called a 2130, 21 days to cure the problem, or 30 days to vacate. This needs to be in writing. It's not sufficient that a landlord just calls or talks to a tenant about a problem. This needs to be written. That gives the tenant notice that you have 21 days to fix it. Let's say that the lease says you cannot have a pet, and then it turns out the tenant has a dog. The landlord would need to send a written notice to the tenant that says you have a pet and you're not supposed to have a pet. The lease states here you're not supposed to have a pet. You have 21 days to get rid of the pet or 30 days to move out. If the tenant fixes the problem and gets rid of the pet, then they can't be kicked out of their unit. They fixed it. There's no problem there. If, on the other hand, the tenant decides, I love my pet more than my unit, they have 30 days to leave. And if they don't leave, then again, we can begin the process of eviction, which begins with the filing of the unlawful detainer, similar to the last slide section. If there is another violation of breach of lease, that becomes a question of, is it the same issue or a different issue? Let's say the tenant responds to the landlord about the dog and says, I've gotten rid of the dog. Landlord comes by, doesn't see a dog, no proof of dog ownership, content, everybody's happy. Another 2 months go by, landlord sees that there is a dog, the dog came back. He does not, or she does not need to give a new 2130. The tenant is already on notice that this is a problem. So the tenant must fix the problem. The landlord can just give us what's called a straight 30-day notice to vacate. Hey, we talked about this in the past. You had a written notice previously. You did it again. So please just leave the unit in 30 days. And that's it. If the tenant has a new issue come up, so for example, the dog issue is resolved, but now the tenant is playing music too loud at night, the landlord cannot just give a 30-day straight notice. That's a new issue. That needs its own 2130 notice to cure. And then go so forth and so on with the unlawful detainer and whatever else might be. Those are important distinctions to understand. There's a final caveat at the bottom of the slide. You'll see 3 stars. If there is an immediate, serious enough issue like criminal or willful, threatens health and safety, the landlord can just terminate. You know, if somebody is doing something that causes harm or can cause harm or has caused harm to another tenant, for example, if their dog has bitten another tenant and it turns out that dog has a history of biting people, the landlord can just terminate the lease and require them to leave, because that is a different category of conduct, a more severe category. Okay, next category, end of lease. This is different than conduct. This is different than non-payment. As we stated with leases, they have a natural term of life. When the lease ends, if the landlord is not interested in renewing the lease, they can give a 30-day notice ahead of time and say, hey, the lease will end at the end of October. This is September 20 something. I'm letting you know I do not want to renew the lease. I'm letting you know I don't want you to be there at the end of the term. Find new housing. This becomes very specific about the lease language. Some leases will have language that says if neither party wants to move out, the lease will automatically renew for another year. Or some leases will say at the end of the term, the lease automatically becomes a month to month. I've seen leases that are the opposite, that say things like, you have 60 days, you need to give the landlord 60-day notice if you want to extend the lease or if you want to stay past the termination date. So this is where it becomes really important. What does the contract say? What does the lease actually say? You can't require a landlord to continue to rent the unit, but the lease can be amended to say that. So what does that mean? You can draft a new lease. You can draft a shortened lease that says, you know, lease terminated at this date. I want to stay until this date. I would like to enter into a new lease for these many months or this year with this landlord, have both of you sign it, it's a new lease. As soon as you pay first month's rent, you've solidified a new contract agreement. Changes to the lease are an important detail. So the lease term ends, and then let's say someone goes to month, which every 30 days is a new lease. If that happens, the terms of the original lease are controlling. The landlord cannot just change the terms and say, well, now you can't have pets. And then next month, well, I decided your rent's going up now. And then another month, I also decided this and that and whatever. They can't do that. The contract terms need to be changed by both parties in written agreement. It can't just be a one-sided situation. That would allow for so much rampant abuse. It's not permissible. So when we go to a 30-day notice or 30-day month-to-month lease, the notices for termination of lease have to happen before the next rent is due. So for example, if somebody enters, let's say somebody entered into a month-to-month tenancy starting October 1st, right? We're in October. The landlord cannot now give a notice saying, hey, before November, you need to move out. That doesn't give them 30 days. The landlord would have to say now, hey, before December 1st, you need to move out. That actually gives them 30 days notice plus. So they've met the requirements of the statute to give people notice that they can move out. These cases are extremely hard to defend if the notice is correct. What that means is that if there's not a flaw with the notice, there's no real defense for the tenants. If the tenant's claiming that this is happening out of retaliation or is termination for a discriminatory purpose, like for example, race, national origin, language, whatever it could be, that's very difficult to prove. So it's not impossible, it's just that that's something to be aware of. It's an uphill battle, unless they have something blatant, text messages, emails, things in writing that clearly show a bias, it's very difficult to prove. Okay, so now we're going into the process of eviction, right? We've talked about entering into leases, we've talked about ways that leases terminate, the 14-day notice, 2130 notice, a straight 30. Now, what does it all sound like? We talked about a little bit of this at the redemption slide, so I'll go over this pretty quickly. Everything starts with the notice. Everything starts with a written notice. If somebody never received a written notice, but was only told on the phone, you have 14 days to pay or quit, it's not good enough. That is a very strong defense to an eviction, that the statute requires things in writing. So traditionally, the pay or quits are 5 days. There's a current statute in place that says up until the end of June of 2022. So starting July 1st of 2022, it's been 14 days because of the pandemic. That can change. They might go back to 5 days. I hope they don't. 14 days actually allows people another pay cycle to be able to pay rent. So hopefully that'll stay. Or it's a 2130 for, like I said, 2130 to cure or not, or immediate termination. This is something that cannot be fixed, threatens harm and safety. So that notice goes out. Tenant doesn't leave, doesn't adhere to the notice, or just can't leave. They can't afford to leave. They don't have enough for a new security deposit and a new first month's rent. So now the landlord can file what's called the unlawful detainer. So now we're going into the court process. So they'll file the unlawful detainer in general district court. They'll pay their fees. They'll be put on what's called the hearing docket. This is the first return that we talked about. So the first return is important because this is a scheduling conference, and this is the first opportunity the tenant has to deny or challenge the allegations against them. The important detail here is that if the tenant does not appear at the first return, they could lose, especially if the landlord has an attorney. Most landlords will be represented. They'll see the tenant doesn't show up, the request was called the default judgment, it's automatic. Our legal system works in the fact that if you think you have rights, you need to defend those rights. The judge is not going to go out of their way to say, well, this was improper. It needs to be the tenant that shows up or the tenant's counsel that shows up to say, this is improper. After the first return, we get into what's called trial. At the first return, we can request what's called pleadings. Pleadings are documents that will expand on what's happening, on why the landlord believes they have a case or claim of harm or damages. And then the answer and grounds of defense, the defendant, in this case, the tenant, will be able to state, well, this is why I don't think you have rights to this. This is why I don't think you should win. You didn't do these things correctly, things of that nature. The trial will be scheduled within a week or maybe a couple weeks out if there's pleadings. It's a very fast turnaround. It's a very fast turnaround for housing. Within 30 days, it's fast. Then there'll be a decision. The judge will hear the two sides, will consider evidence, will make a decision. If they side with the tenant, case gets thrown out, tenant gets to continue living there. Landlord, we either have to do it again from scratch, or the tenant might have fixed the problem and it's no longer a problem. Or the landlord will win, at which point you can ask for possession of the property, damages in terms of monetary damages, and can request a writ of eviction. If the writ of eviction is granted, you would have to go to the clerk's window to turn it in. And then the clerk would contact the sheriff, as I discussed on the redemption page, and that process would begin. This is just a slide that points out what the summons for an unlawful detainer looks like. On the top corner is going to be the information of the court. The top center where it says case number, landlord's information, tenant's information. The far right says hearing date, and that's the important dates of when people need to show up and by what time. The left middle says claim and affidavit. That's where it explains what the case is about. What are they claiming is the harm? Do they just want the possession of the property? Do they look for, is it unpaid rent? Was there some sort of criminal activity? Is it a dangerous situation? Those details will come into play at that spot. So those are the types of things that will be explained in the summons. And those are important things to know and to realize what's happening for this individual. Next slide, please. So this is a quick summary. Everything starts with the lease, right? Verbal or written, there will be a lease. If somebody is renting from somebody else, as far as the law is concerned, a lease has been formed. Notice, either it's going to be a 14-day notice, a 2130 pay or quit, a 30-day notice, or if it's criminal or life-threatening, immediate termination. There will be a written notice that will start off the eviction process. After the written notice timeline has passed, we're going to move into court papers. Unlawful detainer will be filed, the case, things of that nature, and other considerations that revolve around this process: income, expenses, disability, housing conditions, reservation of rent. Okay, subsidized housing. So subsidized housing has extra layers of protection built in because these are getting into federal programs. Now we're also discussing federal law as well. Subsidized housing includes things like public housing, Project 8, Section 8 vouchers, senior residencies, low-income tax credit properties, housing choice voucher, Section 8. Usually if there's a voucher involved, that's a tip-off that it's going to be subsidized housing. If somebody presents a lease that says LIHTC, that's subsidized housing. The reason this is important to understand is that there are more strict procedures in place for unpaid rent issues, termination of lease issues, things like that, because these individuals are living in or below the poverty line, and those are things to take into consideration. As the slide says, this is not an exhaustive list. There are other factors that come into play. There are other defenses available, things like that. A lot of the cases we see in these situations with subsidized housing tend to be termination of subsidy or recertification issues. For example, somebody wants to continue the lease, or the landlord wants to get out, or the tenant wants to leave, but there's a certain timing variant involved, and things of that nature. Again, this is getting into federal law, so it's different legal sets outside of the Residential Tenant Act that governs in Virginia. Or they could be reasonable accommodations. So a reasonable accommodation, we start getting into medical issues, medical concerns, rampways, wheelchair access, things of that nature. Okay, new category, unlawful ouster. What does that mean? That is when the landlord has by themselves evicted or effectively evicted the tenants from a location. So that is not allowed. Virginia does not allow what's called a self-help eviction. Only the sheriff can remove people from property. Only the sheriff can remove people from property. Cannot emphasize that enough. So the landlord cannot physically remove somebody from a property. They can't change the locks on them, preventing them from entering the property. And they cannot shut off the utilities improperly. So what does all that amount to? The tenant has a contract to be there. The contract is the promise that for these dates to these days, they're allowed to live there. The tenant will pay rent to do that. The landlord cannot unilaterally just decide, well, I've been wronged, so I'm going to do X, Y, Z to retain my possession. That doesn't work. The court, who's an objective arbiter, needs to be involved to look at the evidence and make a decision who's in the right, who's in the wrong. The other crucial thing to remember is that only attorneys can appear for other parties. For example, if the landlord is not a person, if the landlord is a company, and the owner of the company shows up to represent the company, they cannot do that. If it's a company, they need to be represented by an attorney. The landlord is not the company. They're two different entities. So there has to be an attorney attached to that case. So if somebody is unlawfully excluded from a tenancy, there is a procedure in place for them to get back in. This is known as filing a petition for relief from unlawful unlawful exclusion. So previously, the petition had to be filed with the landlord before the tenant could get an order to recover possession or resume utilities. I've mentioned this before. What does that mean? If you cut off electricity, if somebody cuts off water, cuts off gas and heat, that makes a tenancy unlivable. That is an effectively evicting somebody. If you're forcing them out because they can't survive, that is illegal. They cannot do that. As of July 1st, 2020, a judge can issue what's called a preliminary order ex parte if they find that the petitioner attempted to provide the landlord with actual notice of the hearing and finding good cause to do so. So that means that, let's say somebody's been locked out of their apartment. They send a text message to the landlord saying, hey, somebody changed the locks. I need to get back in for my things, and I need to get in because I have nowhere else to live. What they can then do is print out that text message, go to the court, file for a petition with the court for relief from unlawful exclusion. So show that to the judge, explain to the judge, I have nowhere else to live. All my things are in there. I have insulin in there. I need my medicine to survive. And the judge can just decide, okay, issued, relief granted. And with that, they're moving the situation forward. They're making it an urgent thing to fix. So a full hearing must be held within 10 days. They're still giving the landlord the opportunity to argue the opposite side of it, but they're not forcing people to just live out in the cold for 2 to 3 weeks, waiting for their chance to be heard at court. They're expediting the issue. They're making it move forward. There's also now actual and statutory damages the tenant can recover in these situations. So let's say the tenant has been locked out for a couple of days or a week, didn't receive any monetary harm from that, for example. They don't have direct harm to show relief. However, under the new statutory code, they receive a $5,000 statutory harm. And that's meant to deter people from doing these types of evictions, because now there's also a $5,000 penalty on the line. Oh, and or attorney fees, forgot to mention that. Okay, maintenance. Now, if you haven't, if I didn't mention it earlier, the focus has shifted more to the tenant's rights and assertion in this section. This is if the landlord is not maintaining the property. Under draft statutory code, the landlord needs to maintain the property, needs to maintain it fit and habitable. A lot of leases try to shift that burden to the tenants, but under the law, the landlord needs to do the work as well. If for some reason the landlord isn't keeping it maintained, you cannot just stop paying rent. If you don't think he deserves the rent, you can put the rent into court. You can file what's called a tenant's assertion in court or repair and deduct, but you can't just stop paying rent. You need to go through the proper channels. I mentioned the last slide, a tenant's assertion or what's called a repair and deduct. Both of these start with a written notice to the landlord. Previously in the presentation, I mentioned how landlords need to give written notices to their tenants. On this side of the coin, written notice must be sent to the landlord from the tenants, alerting them of the situation. That's just being fair, right? If it's one side who has to give written notice, so does the other party. Once the notice is given, the landlord has received notice. That's important to verify or prove landlord received notice. Use an email, use a text message, use certified mail, something that shows proof that they knew about it. Because that way in the future, they can't just say, well, I never received the document, or I never received the email. Put the onus on the other party to prove they didn't receive something. Reasonable time needs to be granted after that. You can't just automatically go and file a tenant's assertion. If the landlord responds and says, hey, thank you for letting me know about the heat, I have somebody heading out, the earliest they can do is 2 weeks. You can't just slap your hands and say, okay, I'm gonna go file tenant's assertion. They have to be given the opportunity to fix the problem. If the repairs don't stick or they don't attempt to repair anything, then you can file into court what's called the tenant's assertion. You can then also pay rent into the court. Well, not rent, you must pay the rent into the court within 5 days of the due date. So rent's due on the 1st of every month. You don't want to pay the landlord because he's not fixing the washer dryer. You file the tenant's assertion, you can pay the rent into the court. And then the court knows, look, they're paying rent, so they're up to date on rent, but you're not getting the benefit of the rent because you're not maintaining the property. You're not keeping up to your end, landlord, of making sure they can live comfortably in their location. So the landlord can always defend, right? This is a legal case. They have a right to a defense and they have rights to pointing out what they think is the problem. They might try to shift the burden on the tenant because maybe the tenant caused the condition. They might try to say that the issue is moot, it doesn't exist, or they fixed it. Now this is starting to sound a lot like the 2130. It is, just in the opposite direction. There's another option called repair and deduct, and this is very straightforward. The tenant has to give a written notice to the landlord. You have to fix the pipe in the plumbing in the kitchen. It's leaking, it won't drain. Landlord doesn't do anything for 2 weeks. That's 14 days. If they don't take reasonable steps to fix it, now the tenant can contract with a professional third party. Has to be a licensed contractor. It has to be a professional contractor. If the repairs and the fix is less than $1,500 or less than 1 month's rent, then that amount has to be deducted from the rent for the upcoming month. Because the tenant had to go out of their way to fix a problem that the landlord should have fixed. They paid $1,000 to fix it. The rent must be reduced by that amount to make the tenant whole again. Security deposits. Everyone knows about security deposits. If you're renting, you pay them. There are now limits to security deposits. A security deposit cannot be more than 2 months' rent. The security deposit is held by the landlord until you move out, and the idea is to cover any cost of damages above reasonable wear and tear, and that's an important distinction. A lot of that starts getting into the nitty-gritties of what is considered reasonable wear and tear, what is considered the lifespan of an object. You know, certain things, everything has a lifespan, everything has deterioration that is just attached to it. And so you can't be charging people the whole carpet as if it's a brand new carpet when it's been in there for over 10 years. Obviously, it's going to wear down over time. So you can't keep the whole security deposit when that is not fair. Only if the tenants slashed the carpet, did something to actually damage the carpet, can they then use the security deposit to repair the issue. Within 45 days after move out, the landlord must return the security deposit, or if not, they have to send an itemized list explaining why they didn't return the full amount or any of it to the tenant. If these things don't happen within 45 days, or the tenant disagrees with the list of itemization, thinking that they didn't do this or that this was already a problem before they moved in, they can go to court and sue for the return of security deposit. Okay, so that wraps up my half of the presentation. Ms. Meghan Zimman will take over and she'll take you to the end of the presentation. Thank you, everyone. It was a pleasure talking to you today.
Thank you so much for that, Edgar. You did a great job presenting a lot of information in a brief amount of time. So thank you so much. Again, this is all based on Virginia law. And at this time, I'm going to start with COVID-related protections in Virginia for non-payment of rent. Landlords are pursuing rent cases in two ways. One is an end of lease termination. A landlord may decide if the lease has ended and they do not want to renew, they can file or they can serve what Edgar described as a 30-day notice, which will require the lease to terminate. And if in that notice period the tenant does not move out, then the landlord could file a suit to have that tenant evicted. Additionally, even if there's still non-payment of rent due. Additionally, non-payment of rent cases arise where the landlord has given a 14-day notice with the requirements from Virginia law that allows them to proceed. And in Virginia, through June 2022, no landlord shall terminate a residential tenancy or take any action to obtain possession of a dwelling unit for non-payment of rent if the tenant has qualified for unemployment benefits or experienced a reduction in household income, incurred significant costs, or experienced other financial hardships due to the COVID-19 pandemic. This is very broad, and most people will be eligible for rental assistance on this basis. Most people have heard that for a good part of the pandemic, or at least for the last year through August, the CDC had issued a moratorium, and that has been struck down by the Supreme Court and is no longer in effect as of mid-August. So this slide is going to go over 14-day notices and the pandemic requirements under Virginia House Bill 7001. Again, through June 30th, 2022, a landlord cannot take action to obtain possession or to evict someone based on non-payment of rent unless a landlord has taken steps first. And one is that they have to serve the notice, and the notice must include that the landlord will apply for government rental assistance on behalf of the tenant unless the tenant has told the landlord that they have already applied for this assistance. The landlord must also give information for 211 Virginia and rental assistance information. And if the tenant is applying, the landlord must provide documentation that is needed to complete their application. For example, W-9 or a rental ledger. So a landlord can obtain possession based on non-payment of rent. That is, they can pursue an eviction based on non-payment of rent for a tenant who refuses to apply for rental assistance or cooperate with the landlord's application. If the application for rental assistance is not approved within 45 days of applying, And that is not the start of the application, but it's 45 days from the completion of the application. And sometimes applications require some back and forth with the agency that is processing the application. So in our view, it's 45 days from the date that the application is deemed complete. If a subsequent application for rental assistance is not approved within 14 days of applying, and that is if someone had already received rental assistance earlier in the pandemic and they applied again for more assistance, then they don't have 45 days to get approved, but 14 days. If the tenant does not qualify for any federal or state rental assistance, if the rental assistance is no longer available, although right now the government funds are pretty full, and administering the funds has been a slow rollout. It's getting much better. And if the tenant does not qualify for unemployment or has not been financially impacted by the pandemic, or if the landlord files an eviction action based on something other than non-payment of rent. So that could be the end of lease or conduct, that sort of thing. This is just a brief summary of where to apply for rental assistance. Tenants can receive up to 15 months of rental assistance through the Emergency Assistance Funds, ERA. In Fairfax County, tenants can apply through coordinated services, and landlords can apply online through the landlord portal, and tenants have to call, and the 222-0880 number is the number for coordinated services planning. Tenants who are not in Fairfax County, but in other jurisdictions in Northern Virginia, apply through Department of Housing Community Development in Virginia, and they have they do have an online portal for tenants. If a landlord owns 5 or more units, the landlord cannot take action to obtain possession for non-payment of rent unless the landlord offers a payment plan. So for example, if the tenant, for whatever reason, didn't apply for rental assistance or got rental assistance but not for a full period, then if the landlord has more than 5 units, they should be given the chance to do a payment plan. They only have to enter into a payment plan once. So for example, if a tenant enters into a payment arrangement and defaults on that payment arrangement, they do not have to re-enter a payment plan. There are new tenant screening procedures as of March 1st, 2021. This is from Virginia House Bill 5106. And this helps tenants who maybe had adverse history on their landlord-tenant record based on something that occurred between March 12th, 2020 and the end of the COVID-19 state of emergency, which ended, so the Virginia state of emergency ended on June 30th, so it would be the end of July. And a landlord cannot take any adverse action against an applicant for tenancy based solely on history from this period. So lots of folks are back on their feet now, ready to move out or have moved or wanting to move somewhere. If there was a negative history on their account or history during that period of March 12th through July 30th, the landlord cannot use that as the sole basis to deny them housing. There are rights by the tenant if they have been denied housing based on this. And there's also statutory damages and attorney's fees available to the tenant if they have to sue affirmatively. Additionally, in January 2022, there will be new protections for getting an eviction case expunged from the record. Currently, an eviction filing against a tenant stays on the court record for at least 10 years, even when the lawsuit is dismissed. And this can make it more difficult for tenants to secure rental housing. And beginning in January, if an eviction action is dismissed or non-suit is taken, the tenant can file a petition to expunge the record after 6 months. Upon finding that the unlawful detainer was dismissed or a non-suit was taken, the court can, without a hearing, enter an order requiring the expungement of the court record. This is, we see this a lot. A lot of tenants have resolved their case and the case gets dismissed, or a non-suit is another type of dismissal that's not prejudicial to the landlord. And this action will help clear up the record because if there was a dismissal of the case, there wasn't an actual eviction, there was just a lawsuit filed. Now I'm going to move on to other landlord-tenant considerations. These are protections in place not necessarily related to COVID-19, but are helpful for tenants to know as they navigate their tenancies. The first is with fair housing. There is protections based so that a tenant cannot be discriminated based on race, color, national origin, sex, family status, elderliness, or disability. And additionally, as of July 1st, 2020, they may not be discriminated against based on source of funds, gender identity, and sexual orientation and status as a veteran. These are specific protections in Virginia. And examples of prohibition on discriminatory housing practices include refusing to rent or sell, discriminating against a person with different terms in their contracts, and for example, publishing or posting a housing advertisement that includes a preference for a particular type of tenant or preference. Source of funds is a newer way of protections for our tenants. It means any source that lawfully provides funding to or on behalf of a renter or buyer of housing, including assistance or benefits from a government agency. So for example, this comes up most frequently with subsidized housing tenants who have vouchers, landlords who have 5 or more rental units now cannot say flat out, we don't accept Section 8 vouchers. And that is based on the source of funds protection. Reasonable accommodations are part of fair housing law. And a reasonable accommodation is a change, exception, or adjustment to a rule, policy, or practice or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. There needs to be an identifiable relationship or nexus between the accommodation request and the disability. Examples of this may be if a community has a no pets policy, but a tenant requires an assistance animal, they may request an accommodation so that they can have that pet or that assistance animal, or asking for a parking space to be moved based on a mobility impairment. There's also reasonable modifications where a tenant may ask the landlord to install, for example, grab bars in the bathroom or shower. These are all protections within fair housing law. Additionally, survivors of domestic abuse have protections. Their history or their status as a survivor of domestic violence could be the landlord previously the landlord did not have to consider a person's status, but now a landlord must consider a person's status as a domestic abuse survivor when reviewing a credit score and a report. Frequently we see our our clients who are victims have financial abuse, where their abuser may have taken out a large amount of credit that has negatively impacted them and thus their ability to gain housing independently. And now with evidence from a police report, court order, or a letter from a domestic violence program, the landlord can consider that any negative history was based on that abuse and should help them gain housing. Additionally, as of July 1st, 2020, a landlord has to offer what's called a Virginia Statement of Tenant Rights and Responsibilities. The statement must be signed by the landlord and the tenant, and the landlord may not pursue an eviction unless the statement has been signed. There is a picture of the Statement of Rights on the left here. Additionally, previously, a tenant who was in public housing would have received notices that had to include the name and address, phone number of local legal aid when terminating a tenancy. And now and not just public housing, but all subsidized landlords must put this information in any termination notice, which would allow the tenant to seek assistance through like our office, Legal Services of Northern Virginia. This covers HUD programs and low-income housing tax credit properties. The landlord may only charge a late fee if it is provided for in the rental agreement or in accordance with the default lease provisions that Edgar discussed, where you have a verbal lease that has statutory provisions. And as of April 22nd, 2020, a late fee may not exceed 10% of the periodic rent or 10% of the remaining balance due and owed, whichever is smaller. So what this equates to is if a tenant has a housing choice voucher and their tenant portion is $100, if they are late on their rent, the late fee would have to be 10% of their portion of rent, their periodic rent, $100. So their late fee would be $10. If that same tenant paid partial amount, let's say they paid $50 and they still owed $50, the late fee couldn't be $10, it would be $5 because it would be based on the remaining balance due because it is the smaller amount. This has been a huge help for our tenants because previously there was not a statutory cap on late fees. So we would see tenants who had, for example, their periodic rent was $100, their late fee may also be $100. So we're really glad that there's now guidance on this aspect. I wanted to close out our presentation with some takeaways for our viewers to remember. When someone has a legal issue, it's often too late to wait to call legal services if the case is already in court. So it's great to have someone be proactive. Don't wait to call Legal Services of Northern Virginia. We can, having advice early on in a legal case is really helpful and allows us to prepare. Although we do help tenants in the very last minute, and often it's easier for us to reduce the crisis for the family if we have more notice and the client has more time or better planning. If a tenant gets a notice or feels their rights have been violated, they should also call for some preliminary advice. Document everything, put all communications in writing. So for example, Edgar was talking about conditions in a property. And if you call your landlord and say, oh, there's mold growing in the bathroom, I need you to come fix it, and they don't come fix it, and then you go to file a tenant's assertion, you're not going to have good proof that you put the landlord on notice. So documenting everything is really key. We recommend writing a letter and having it a copy of that letter, email, even screenshots of text messages could be another way to document. But having communication in writing is really helpful. Generally, when doing move in and move out inspections, keep a copy of notes or the inspection report that is created as a result of those inspections, and take pictures. This is really helpful for security deposits. We too frequently see a tenant has moved out and the landlord is withholding their full security deposit because the landlord is now renovating the unit on the tenant's dime. And even if that is unlawful, it's really hard sometimes to get the security deposit back without good evidence. And lastly, if you expect to be late on rent, call for help with rental assistance applications. Even if you're not sure if you're eligible or you've already gotten assistance, these programs are evolving, and we're finding that people are able to secure housing based on the assistance that is available. I've included our website and also our phone number, and appreciate you listening to our presentation today. And thanks again for having us to do this presentation.